Good afternoon. This is Emmanuel Holowale. Welcome to another edition of Legal Angle with Emmanuel the Law Holowale. Today I have with me a special guest, someone who has been a judge for over 24 years. He has been an attorney for about 45 years, and he's currently running to be the Franklin County City Prosecutor. His name is Gary Tyack. He's going to be talking to us about the intersection of being a judge and being a prosecutor. So, intersection of judging and prosecuting. So, Judge Tyack, can you please introduce yourself to our audience?
Okay, my name is Gary Tyack. I have always had to spell Tyack when I was a little person. When I got introduced to someone, I said the last name, but my folks always spelled the name because nobody ever knew how to spell it. I suppose you've had to deal with things like that yourself, Emmanuel. I grew up here in the Columbus area, attended the Columbus Public Schools, and came out of high school here in Columbus, Whetstone High School. I helped open that school. Came out of high school and firmly planned on becoming a member of the religious clergy, and went to college, declared a religion major, also studied a lot of math, and then I worked in a settlement house in Chicago for 2 summers, and the experience there led me to think that maybe there were other things I wanted to do. Now, this was at the height of the Vietnam War. I got out of college in 1968, and when I wasn't going to be a minister anymore, then I was healthy. I was a swimmer for many years. That meant that I was going to end up going into the Army, and so that's what happened. In 1968, I entered the U.S. Army. Eventually decided I wanted to become an ammunition officer. My father very much wanted me to go to officer candidate school. So we had some things we disagreed about over the years, so I didn't feel like fighting him about that. So I became a lieutenant in the U.S. Army, and I know more about U.S. Ammunition than maybe anybody will ever learn to know. The result was that when I went to Vietnam, and I did go to Vietnam for a tour, I never shot a weapon the entire time I was in Vietnam. I sat on top of as many as 80,000 tons of ammunition, not pounds, tons of ammunition. And our job was to make sure that the people who actually did shoot weapons always had the ammunition that they were supposed to have. So I did that for a year and came back to this country. I never thought I would live through Vietnam, so I didn't plan. And then I ended up doing making it back here. And I had been accepted to graduate school in mathematics at the University of Wisconsin. So since I didn't really have plans, I just followed up on that. Spent a year being a math grad student, and it went well, but it wasn't very exciting to me. Partway through, because I was interested in politics and because my time working in Chicago, I had seen how much lawyers could do for people. I decided to go to law school, and so I went to law school. Now, my veterans benefits were going to run out, so I ended up going straight through law school. I went through law school in 2 years and 3 months, and then took the bar exam in the winter of 1975, passed it, and have been a lawyer ever since. The law practice I had was a people practice, people with divorce cases, with traffic cases, with personal injury cases, even such things as drunk driving. And I ended up also spending a bunch of time trying major criminal cases. I handled death penalty cases, which has been an interesting experience, but it was it was part of what I did. I was always the person trying to keep the government from killing somebody. And so I handled several of those in my lifetime. Eventually, I decided that I wanted to do something different, and there was an opportunity for me to become a Court of Appeals judge. And so I accepted an appointment from the governor of Ohio, who was Dick Celeste at that time, to be on the 10th District Court of Appeals. I enjoyed the experience. Columbus was not real good about electing Democrats at that point in time, and so I didn't win my first election, but I came back a few years later and ran a second one and spent 12 years on the Court of Appeals, and then had a brief return to private practice of law. And then I did 12 more years of Court of Appeals. So all told, I've done 24 and a half years as a Court of Appeals judge. And I can't do that now because I'm too old. Ohio has a part of the Constitution which may not make a lot of sense anymore. But when we had the so-called Modern Courts Amendment many years ago, we decided that no one could run for another judicial term once they had turned 70. And since I had turned 70 before the election a year and a half ago, I ended up ending my judicial career. I have been concerned about the way things have happened in the prosecutor's office for many years, partly because some of the cases I was trying, also because, for instance, I had a situation where I got called by a woman I had represented years earlier, who said that her 14-year-old stepson had been shot in the back by a police officer, and they weren't doing anything about the police officer, but they were going to pursue criminal charges against her son. And so I ended up representing that family for free because I didn't feel the charges should have been filed. And we ended up dealing with that situation, but it showed me that there are times that when a police officer does something not so good, that they don't get penalized for it. Now, I had earlier, part of my practice had been representing some police officers in different kinds of things. You may not know that at a time in Columbus, if you were African American or dark complected, if you finally got to be a member of the police department, you had to have a partner who looked like you, and therefore was also dark complected. And then you only were allowed to patrol in areas that had mostly African American and dark complected folks. And so I represented a number of police officers in that situation. And as happens with anyone, there were some situations that came up where the mahogany row, as they call it in the police department, the upper level folks were not 100% pleased with what an officer had done. And so I ended up representing a number of police officers on disciplinary matters. Give you an example. One of my clients was really, really nice guy who encountered a guy who was a career criminal in the near north end of town. And the guy he was going to arrest ran away and got in a van and started driving away. And under the police regs, you're not allowed to shoot at somebody unless it's in self-defense of yourself or if it's defending someone else who's in serious danger of being harmed. Well, my client did sort of the Hollywood type of thing. He tried to shoot the tires out of the van that this guy was fleeing in. Wasn't trying to shoot the man who was driving it. He was just trying to immobilize the van. But under the police regs, he wasn't in danger at the time. So he didn't, what he did wasn't right. And I helped him with his disciplinary charges. Had another police officer I represented who had been in a police cruiser on the Near East Side of town with his partner, and somebody walked up to the police cruiser and fired a sawed-off shotgun into it and killed his partner. Well, I don't think my client got a good look at who did it, but there was a senior homicide detective who was sure he knew who had done the shooting. And so my client accepted what the officer said. And I mean, obviously, if you're a police officer and your partner gets killed, you want somebody to pay for it. And so he ended up testifying at the trial of a man by the name of Thrower. Well, and I think Chuck McFadden, my client, was convinced in his own mind that he was identifying the right person, but he wasn't. And later on, the person who had actually done the shooting got caught, and by that time, Thrower had done 8 years in prison, and so Chuck, they started Chuck disciplinary charges against Chuck McFadden, my client, and yeah, he made a mistake, but I ended up trying his disciplinary matter for 3 days in front of the safety director, and when it was all over, they decided that he had made a mistake, but that it wasn't the kind of thing that should have a serious discipline as a result. So Chuck got told, don't make any mistakes for the next few years. So I have done a lot of different things in the law. The Court of Appeals here in Franklin County, the 10th District Court of Appeals, is a very important Court of Appeals because of state government being here. And because if there are mistakes in state government, frequently they come before the 10th District Court of Appeals. The other side of it, though, is that if people don't, the State House, do bad things, the Franklin County prosecutor is supposed to investigate it and is supposed to pursue criminal charges. And that just hasn't happened. Larry Householder, the guy who just got removed as Speaker of the House, got investigated by the federal government years ago, and no charges were filed. And that case just went away. And then, of course, recently he got charged again with this $60+ million worth of bribery going on, and he's we'll see what happens with that. But I happen to think that the guy who's the current prosecutor just hasn't done his job when it comes to prosecuting state government people. Mm-hmm. And part of what I hope I can do is clean up some of that. Mm-hmm. But that's maybe that's more than you want to hear. But
this is a good transition. Last 2 weeks, I interviewed a guy who spent 20 years in jail for a crime he didn't commit. He and two of his friends, they were teenagers at that time. He was 16 years old when he was arrested for murder, and he got convicted the next year, got sentenced to jail for 15 years to life. He spent 20 years before he was exonerated, by the help of the Ohio Innocence Project. The reality is that they spent 20 years in jail for a crime they never committed. And 3 years down the line, when he filed an appeal, there was evidence that could have been provided to the defense counsel that would have gotten these guys off. However, the prosecutor at that time wrote a letter to the Cleveland Police Department not to release any information or evidence to the other side. So they hid evidence that could have set these guys free. And they spent 20 years in jail for a crime they never committed. And the only thing common with all these guys is that they are all Black from the inner city, and they didn't have the right, no one was there to listen to them. So when you become a prosecutor, how would you ensure that errors like this, which makes people, someone spending 20 years in jail or in prison, it's not 20 years is a lot of time to lose. Even 2 years of anyone's life for something you didn't do is a lot. How would you ensure that situations like this will not occur under your watch?
The first thing you have to do is you have to really study who the homicide detectives are, who some of the detectives are. And that case, that thrower case I mentioned where I represented Chuck McFadden, there was a senior homicide sergeant who felt that he always knew who was guilty, whether he knew the right thing or not. And so we had huge problems in that when I tried like a half dozen murder cases where he was involved, and in each one of them, what happened was that his informants, and he had a bunch of people that owed him or that were on the streets. His informants would come into the trial and always say, I talked to the defendant right before the homicide, and the defendant said he was going over to commit the homicide, or I happened to be walking by when the homicide happened and I saw your client do this, or I talked to your client right after the homicide had happened, and your client admitted that he had done it. It was always a lie. This one homicide sergeant always got some of his people to walk into court and lie to try and make it look like that somebody was guilty. And so we had years and years of that kind of problem. This man was just in the legalese. He was suborning perjury. He was getting people to support what he said happened, even though it wasn't what happened on the street. Interesting sidebar on that is that one of the people in the prosecutor's office at that point in time was Steve Hayes, the son of Woody Hayes, the football coach. And Steve got skeptical of this homicide sergeant. And so he worked with me on a case we had. He said, I don't think that the people that are involved in this case actually saw what happened. And so let's set up a little hearing. So we set up a hearing in front of the judge. I did a motion to dismiss. And so the three people who this homicide detective, Tom Jones was his name, the three people that Jones had claimed to the grand jury had identified my client as being the murderer. We pulled them into the courtroom, and the average person might not understand how some of the courtrooms were set up, but the witness chair was, like 5 feet, 10 feet away from where the accused sat. And so we pulled in the witnesses that Hayes was skeptical about, and Hayes didn't cue them in as to who they were supposed to identify. So they came in and they sat down in the witness chair and were asked, is there anybody in the room you have seen before? And the first one looked all around the room, and said, no. Now this person, according to the detective, had identified my client as being the murderer. And so that was the first one. Second one, same deal. Person comes into the room, looks all around, and says, no, I don't see anybody I've ever seen before in here. So there's the second witness out of the three. The third witness comes in and is sworn under oath and sits in the witness chair and gets asked the same question. And he looks all around, and then identifies the courtroom bailiff as the person who he might have seen before. Well, after that, Steve Hayes moved the judge to dismiss the case, and the judge readily accepted it. But that same homicide detective kept doing being a homicide detective for a bunch of time, and the average citizen on a jury doesn't really ever want to believe that a police officer would lie under oath. They just don't want to believe that somebody who is sworn to uphold the law will turn around and then lie under oath to identify or to strengthen their case or so forth.
Exactly.
one of the more recent cases I had, I got called by a woman who had been a client years earlier, and she said, my 14-year-old stepson has been shot in the back by a police officer. Nothing's happening with the police officer, but my stepson is down in the juvenile detention center, and they're charging him with felonious assault. I saw the photographs and talked to some of the witnesses, and the photographs showed that the police officer had squeezed off 3 rounds, fired 3 shots at the back of a car my kid was fleeing in. No one was running toward the police officer. No one was getting hurt. There was no danger of someone being hurt. But the officer, I think, was just angry that the person who was stealing the car was going to get away. And so he ended up firing 3 shots, one of which hit my client in the back. Fortunately, most of the impact of the bullet was absorbed by the glass in the back of the car. So it went through his back to the point of hitting his ribs and back and stopped. It didn't make it into his heart or his lungs or his things like that. But we have a problem that the police sometimes do marvelous jobs, and sometimes even they make a mistake, they get their rear end covered by the current prosecutor. And it shouldn't be that way. If somebody shoots an unarmed person, it shouldn't be, oh, well, they help us in all these other cases, so we're not going to do anything about the shooting.
Exactly. So, how do you propose to hold police officers accountable when they abuse or misuse their power?
Well, the first thing you got to do is you got to know who your good officers are and who your bad officers are, and you need to weed the bad officers out. I think a lot of people on the department know who's good and who's bad, and there's a lot of pressure on officers to not rat on a fellow officer, not to let know what's going on, because they then get the pressure. Well, you might be the next one who needs help, and so if you have told the truth, the bad truth about this other officer, then you might not have the support you would like the next time. So first, you've got to know the officers. Second, you've got to weed out the bad ones, and that's a minority. That's not most of them. The studies show that like 80% of the police officers that do a whole career in the department, 20, 30 years, never fire a shot at anybody. But there's a few that do, and some of them are shooting in self-defense, but there's some others that just, are angry at somebody fleeing from them or something like that. So you got to know who your officers are. We need to look at the Fraternal Order of Police contract. Right now, if you do something bad, or if you shoot somebody, the first thing that happens is that they say, oh, nobody on the department can interview the officer who shot somebody until after the officer has met with the lawyers for the Fraternal Order of Police. And once there has been a meeting with the lawyers of Fraternal Order of Police, then the person who's done the shooting has always figured out what they should have done and have come up with a story as to how they were shooting in self-defense. Even like my 14-year-old kid who was driving away and was shot in the back. So the police contract needs to be improved, and we don't want to turn over control of police shootings to the Fraternal Order of Police. So that's part of what has to happen. Second, the prosecutor, instead of making a pitch that, police officers, I will protect you, nobody will indict you or charge you no matter what you do, you need to not have that be the word in the department, because there are people in the department who are really distressed about the bad apples. who shoot people and do bad things. And so we need to actually prosecute people who do bad things as a police officer. And the people in the neighborhoods, I mean, part of what's helped this whole situation is body cams. The body cameras end up showing what happens. And so even if a police officer is lying, now you can prove they're lying sometimes. And so the body cameras have to be there. They have to be on. Every once in a while, we have a little problem with somebody says, oh, yeah, I have a body camera, but I didn't turn it on because this reason or that reason. And the fact that they didn't turn it on just happens to be in a situation where they've done something they shouldn't have done. So, and the grand jury needs to hear the whole story. They don't need to just hear what the Fraternal Order Police wants them to hear, because in the last 15 years, I can't think of any situation where a police officer has been prosecuted because the current prosecutor and his predecessor always put this information, this information in front of the grand jury and give them a version of the facts that always say, well, I shot in self-defense, or I shot because I had to protect somebody else. They know when they're supposed to do it, but sometimes, and in fairness, you can understand why a person who's been a career police officer who shoots somebody when they shouldn't have done it doesn't want to risk going to prison, because they might run into people that they've put in prison who might try to pay them back for a false conviction or something like that. Yeah. So I think part of what I can do is keep an eye on who the officers are, to not kowtow to the Fraternal Order of Police, and 3, reward the good officers who are willing to come forward and say, yes, so and so shot somebody in the back from a distance of 50 yards, but there was just no reason to be shooting, as opposed to going into a situation where they feel, if I don't lie to prosecute my fellow officer, then I don't know what's going to happen to me on the streets the next time I'm out with some of our people.
Thank you. Being on the bench for so long, as an appellate judge, do you recall any particular case where you had to overturn a wrongful conviction?
I can think in particular of a death penalty case several years ago where the man that was accused was a not mentally challenged, whatever the words are you're supposed to use now. But when I was growing up, we would have said mentally retarded. That's not the choice that they want you to use now. Yeah. But I had a guy who ended up taking a sledgehammer to the man, to the victim. The situation was that the guy who got convicted was guilty, but he got the death penalty in a situation where, once you knew about his mental challenges and all his other things, the death penalty just wasn't the right result. I also sat on the Supreme Court of Ohio by assignment a couple of times and was really unhappy because I had tried death penalty cases. I had people who the state was trying to kill sitting next to me at the counsel table. And I had dealt with that situation. And I found that there were cases in the Ohio Supreme Court where people weren't reading the transcripts. And in death cases at that point in time, you have a really high burden you're supposed to overcome. Part of why we don't have as many death verdicts in Franklin County as we used to have 20 years ago is that the juries now have an option of life without parole. And a lot of the early death cases where the jurors voted for death were situations where they were saying, I just don't want that person out on the streets again. And it wasn't that they didn't feel for them or understand the terrible background they had, but we had to, we have come a long way on that. I think out of the last 12 death cases in Franklin County, only one of them has gotten a death verdict. 11 of them, the jurors did not get there. So the population of Franklin County has come a long way in feeling that it isn't an eye for an eye. If you kill somebody, it doesn't automatically mean that you ought to be killed, because once you find out what their childhood was like, what their early life was like, things like that, in almost every case, the jury just feels, I understand. Sometimes they even understand to the point of saying, there, but for the grace of God, go I. So I think that it is extremely important that we narrow the amount of money our time we spend on death cases, because on the typical case, we spend hundreds of thousands of dollars to pursue a death case, whereas a regular non-death case costs a lot less. We have spent millions and millions and millions of dollars to pursue cases that Ron O'Brien once pursued as death cases, but where the jury just says no when it's over. You may know that we have twice as many attorneys, both on the prosecution and on the defense, on a death case. And again, very few people in Franklin County go down to the courthouse thinking, I want to kill somebody today. What they think is, I want to be part of a fair trial and do what is right when it is all over. But there are a few on the prosecutor's staff who think right has to mean a conviction, and that's just not true.
Yeah, that was going to be my next question. If you take over the prosecutor's office, how do you plan to rein in the overzealous, either young or career prosecutors who think it's all about winning, not justice?
First, I have the benefit of having been in those courtrooms for a long time, and I have a little insight as to who is good and not so good. One of the cases I tried some years ago was a woman who had a drug problem, and she had been convicted of drunk driving, even though it didn't involve alcohol. She had been convicted of drunk driving a number of times, and then got under the influence and was driving around the North End with her child in the car and hit a tree and killed the child and messed her up totally. Well, the law at that time said that, excuse me, the law at that time said that Riverside Hospital, where she got taken, could not testify about drugs of abuse in drunk driving cases. So the prosecutor's office, who could have worked out a very favorable result without calling it a drunk driving, ended up insisting, even though the lab report said there was no alcohol in this woman's body. She hit the tree, she got messed up, her child died. They had lab work, and the lab work said no alcohol here. Well, the prosecutor involved felt, I might not win this case, whatever win means. I might not win this case if I don't argue that she was under the influence of alcohol. So he argued it and got away with it. The person who was the judge was a recent appointee to the bench and had a tough election coming up and thought she might lose. So she didn't cross the prosecutor's office or the police department on anything. She still lost, by the way. Steve McIntosh replaced her and is an excellent, excellent judge. But I had that kid, my kid who got shot in the back. There was a prosecutor who tried that case and knew that it had not been a self-defense situation by the officer, but still tried the case. And then, like I say, I had the one where the woman drove into the tree and accidentally killed her son. You've got to be able to understand who you've got, and you need to, frankly, weed out the folks for whom having justice in the courtroom is not the most important thing. That's what I want to do more than anything else, is make sure that every person who is tried feels they have had a fair trial and not feel that they have been convicted because a prosecutor pulled sleazy tricks about the evidence or stuff like that. That's avoidable, and the priority has to be fair trials. And I will.
Fair trials.
And I'm not afraid to fire people. I'm not going to do it just because somebody votes in a different political primary or something else like that. That's not what my concern is. I have just seen too many cases, even in my past history, where the trial wasn't fair. And the Court of Appeals doesn't always remedy that. They have to give some slack to the trial court judges. And so I had a number of cases where I just felt that the wrong result was reached, but I couldn't get a second vote. See, 3 judges on a Court of Appeals, you got to have 2 of the 3 of you agree on the whole thing. John Connor and I went through 6 years and disagreed on 1 case out of the dozens we did. There are some excellent judges down there, but there are some who are more concerned about winning their next election and think that supporting the police is the best way to earn or to win the next election. So you've got to make fair trial your priority. And there's a related thing. We've had problems in recent history where expungements were fought by the prosecutor's office. Expungements, somebody has had a criminal conviction and 5, 10, 20 years later wants to undo it because it makes it hard for them to get a job promotion or to earn a living or something like that. And we had, while I was on the Court of Appeals, over and over and over again, situations where a trial court judge, Guy Reese comes to mind, was willing to do the right thing as opposed to make sure every dot in the statute was followed or every T was crossed. So he did, people who had done a crime, and maybe a small crime, 20 years ago, were asking to get their record cleaned up, and he would do it, and the current prosecutor's office appealed over and over and over again. And it's frustrating as a judge because technically what you're supposed to do, but you'd like to think that doing justice is more important. And we had that has been an ongoing problem. I'm sure there are some people down there who know my attitudes and think that between election day and the end of the year that they ought to be looking for employment someplace else. And that's, if they can do it the way I see it and make fairness the hallmark of what they're going to do, we won't have a problem. But if they feel they're going to be rated based on how many convictions they get as to how often there were acquittals, then I want them to find another line of work.
Thank you. You're very right about that. I had a case a while back too, where my client's conviction was thrown out by the same judge, vacated 18 years later. And the prosecutor, instead of accepting the verdict, appealed. And I think we came before you guys to argue that case. I ended up prevailing on that case. But what that case taught me was that these prosecutors that are just out there, that they don't really care about the outcome. They don't really care about the lives behind those cases. They don't really care about the humanity of the people they're dealing with. They only care about numbers. And this particular prosecutor wasn't even the one that tried the case 17 years earlier. Neither one of us were attorneys at that time. So my next question to you is this. And sometimes when cases go up the ladder like that, especially cases of convictions and situations like that, most people don't win on appeal. I've had a situation too where it took about 13 years before I was able to get post-conviction relief for one of my clients. Why is it so difficult for even judges that sit on the appellate court to look behind those convictions and sometimes maybe look at, maybe they got it wrong?
There is a problem, I believe, that there are some judges on the appellate court also who are more worried about whether they're going to win the next election than they are on making sure the law was followed in the trial court. And they're concerned. I can think of two judges I served with for the better part of 12 years who I never saw them vote to overturn a conviction in the 12 years they were there. And one of them is running this year, and actually they're both running this year because one of them is on the Supreme Court now. You've got to be willing to admit that mistakes are made at the trial level, and you got to believe that there are police officers that are capable of not telling the truth or spinning the truth to try and get an outcome. And so it's real important that happen. There are too many judges who are too worried about the next election, as opposed to what was fair. And part of what the benefit I think I bring to the bench and will bring to the prosecutor's office is that I care about people, and I represented people like you're talking about. And I've known what it does to them and their family if they are convicted when they're not guilty. It is, and frankly, as a former criminal defense lawyer, it's the worst case to have because you can't win it. Okay, if you get a not guilty verdict, you just got what should have happened in the first place, and it wasn't that you as the lawyer did a good job. It's just that the jury saw through the prosecution's case. But there are some folks who just can't believe that a police officer would make a mistake. That's another thing that I ran into recently in seating juries, because I tried a number of jury trials. In seating juries and in talking to people that were going to be jurors in a given case, and making them face the question about, well, is it possible that the defendant is not guilty? I mean, you walk in and the way the situation is set up, you're in the room. It's such an important thing as far as the trial. And I think the typical juror, right or wrong, walks in there thinking, well, probably he, and usually it's a he, probably he's guilty. And when you're an attorney seating jurors, you really have to work hard to get them to admit the possibility that somebody that has gotten so far along that they have actually go into trial might not be guilty. You know, we have the presumption of innocence, but it's one thing for people to know, oh, it's an academic matter that there's a presumption, but then they have to really think about what does it mean? What does it mean here? And one of the examples I usually gave to jurors was, okay, if you're driving down to the courthouse and you look over to the side of the road and here's somebody pulled over to the side of the road with a police cruiser with flashing lights behind them, what did you ask yourself? You may have asked yourself, what did he or she do? Not the presumption of innocence that they didn't do anything. It could be that they just got pulled over because they were having trouble with their directions, or there was a problem with the car. But the average person, upon seeing that happen, thinks, "Oh, what did they do that the police pulled them over?" And then I always talk to them about the presumption. Have you given them the presumption of innocence? And people start thinking about those things. I think the average juror comes into the courthouse and wants to be fair, wants to do what the law calls for them to do. But sometimes as a defense counsel, you have to help them understand what that means and what it means to be fair in this case. So it's a tough situation. It's a tough darn thing. And if you have somebody you are convinced is innocent, it's terrible for the defense counsel because
it's terrible.
because if the jury then goes the wrong way and your innocent client gets found guilty, then you're thinking, oh, this person who didn't do anything wrong is going to spend years in prison and maybe have their rest of their life marred by this wrongful conviction. I mean, Alan Thrower didn't kill anybody, but he spent over 8 years in a state prison because there had been a homicide detective that was convinced that he had killed somebody and manufactured evidence to support it.
All right, Judge Tyack, it's been nice having you on this show. Can you tell people who wants to support you, who wants to reach out to you, how they can contact you, and what is it you're bringing to the prosecutor's office that is not there at the moment?
Well, I've had this little sign up for people to watch. It's Gary Tyack for prosecutor, and that's the first thing. There is a website which can be contacted, and you can support me just by telling your friends and telling people that, Facebook and other things, that this is somebody I want to support. And obviously campaigns run on finances, but I don't have 200 people in the office backing me who are, some of them, afraid they're going to lose their jobs. So I will never raise the money that my opponent will, but that doesn't mean that I'm not the best person for the job. So again, it's Gary Tyack for prosecutor, and if they can contact you, Emmanuel, you have my phone number, and I'm not afraid to have it given out, but I don't obviously know whether the best thing to do is to broadcast it. But
all right, I understand.
If people contact you, you're welcome to give it to anyone you think should have it.
Oh, thank you very much. It's been nice having you on this show, and I can see that you have you have the confidence, you have the heart to do the right thing, and I wish you good luck with your campaign.
Thank you, and I will try to always be worthy of the trust that people place in me, and always try to make sure that the trials are fair, and that the courthouse is run by the jurors and sometimes the judges, and not necessarily the witnesses or the Fraternal Order of Police.
Thank you for coming on the show.
Thank you.
And for people watching at home, thank you again for joining us on Legal Angle with Emmanuel the Law Halawali. One thing we should note is that as a lawyer or prosecutor, given power by the state, the city, or the county, your job is to maintain law and order in a way that is just and fair to everybody. It is not about winning. It is not about losing. It is about justice. And when you get in that courtroom, when you decide to prosecute a case, make sure that you are prosecuting the right person and that you are seeking justice, not just winning. Thank you again for joining us on Legal Angle with Emmanuel the Law Olawale. Until next time, bye for now.